Okay, so what I basically did is I went through zip forms and I pretty much grabbed all the documents that weren't like a disclosure, weren't a purchase or a listing agreement, didn't have to do with rentals, and basically isn't something that we weren't going to do like a deeper dive on. So I have most of them here, and I'm not going to go super deep into each form. I'm not going to break them down paragraph by paragraph, mainly because we got a whole bunch. Really, what I wanted to do is just introduce you to some forms that exist. Many of them you've seen and are pretty normal and we use in most transactions, but some of them aren't so much. And so I just wanted to kind of introduce a few of these so you know they exist. You know, one of my sayings is there's probably a form for that. So always keep that in mind when you're trying to draft something up and you're thinking, how should I write this? Just remember, Nick said there's probably a form for that. Shoot me a text and I'll tell you which one it is. Okay. So without further ado, and in no particular order, at one time, this list was alphabetical, but as I've moved things in and out of the folder, they've kind of gotten all over the place, but doesn't really matter. All good. And hopefully most of this will still apply as of December when we get a brand new real estate purchase agreement that's going from 10 to 16 pages. So come the end of the year, or I should say probably in the fourth quarter, maybe in the third quarter, we will start breaking down and doing some classes on that. I haven't even done a class on it yet, but rest assured I will be, and I will be sharing all that with you. So let's move forward. The first document that I've got here is the amendment of existing terms. Now, this is very underutilized. I almost never see this. Why? Because when people want to change things in a deal in the middle of escrow, they usually use an addendum. Well, folks, let me share with you the difference between an addendum and an amendment. Okay, an addendum is adding in addition to, and an amendment is changing or altering, right? So if you're drafting a purchase agreement and you need to add some additional verbiage or some other things that you're negotiating, you would use an addendum because you're just starting a contract and you're adding something to a contract that you're writing up for the first time. Now, if you're in the middle of escrow and you need to make a change, well, that's when you would use an amendment, right? So let's say you're in the middle of a deal and you're changing your purchase price from $1 million to $975. Okay, well, in that case, you would use an amendment, not an addendum. Now, what would happen if you used an addendum? Well, basically, you're saying the price is $1 million and the price is $975. Whereas an amendment saying the price is $1 million, but now we're changing it to $975. So this is actually the appropriate document to change terms in whatever agreement you're talking about, whether that is a purchase agreement or a listing agreement. In fact, CAR recommends that if you have a coronavirus listing agreement addendum in place right now, we should use an amendment or a modification of terms to alter and remove that document because that document says we can't do open houses. So anyways, changing terms, amendment, adding to a new agreement, addendum. All right, next on the list, the additional signature addendum, ASA, very simple. There's really only 2 spots to sign on a purchase agreement or a listing agreement, right? So we have buyer 1, buyer 2, but I've seen purchase agreements with 5, 6, 7 people on them to buy or sell. And so when there's too many people to sign on a document that is allotted for the 2, then we would use the additional signature addendum. So that way we have somewhere in a document that says these people are also identified as buyers, sellers, what have you, and that they're acknowledging receipt of whatever documents are being identified, the residential purchase agreement, the listing agreement, or potentially disclosures, et cetera. Okay. So again, very simple form. There is a checkbox on your purchase agreements and listing agreements where you would check it, and this form will automatically get added, and then you could fill in the additional signatures on this document. Real simple. All right, like I said, I'm going to kind of buzz through a lot of this stuff because a lot of them don't even need a lot of explanation, right? Number 3 here, additional agent acknowledgement. So if you are going to work on a transaction in conjunction with another agent in our office, okay, in one of the offices, and it's in the same office, the Long Beach office, the Cerritos office, La Mirada office, whichever one it is, then we need to disclose to our buyers and sellers. And that's where we would have an additional agent acknowledgement. It's very important to let the clients know, the consumers need to know if there are multiple licensees that are working for them and representing them, okay? And so basically you would just put in our office name, maybe if there is a team. I see this all the time with teams, whereas, you know, you have a team leader that has their name on everything. Well, whoever the junior agent or as the partner agent is needs to declare themselves as well. Okay, so this is the document we would use to acknowledge exactly that. All right. And y'all know the rules here. If you have questions, feel free to interrupt, drop it in the chat, raise your hand, or whatever it takes to get my attention. Happy to help. All right. Next, the AOAA, Assignment of Agreement Addendum. Okay, so this can be used a few different ways, but basically it's when we're either changing or adding a buyer to a transaction. Okay, and you can see there is a partial or total assignment. The partial assignment is when we're adding a buyer to the contract. And then a total assignment is when we take off a buyer and we're adding a completely new buyer. Okay, so this would be the document to alter if there is indeed going to be a different or additional buyer that is either added, taken off, or replaced completely to a purchase agreement. Now, one thing about assignments, in the purchase agreement, the buyer, it notes in there that the buyer is not allowed to assign the agreement to anybody without express written permission. And part of that permission includes whether or not anyone who is assigning a contract is receiving any sort of monetary consideration. So there is a paragraph here that says the seller has been advised that the buyer is or is not receiving monetary consideration. They're making money on this. And this is built to avoid basically wholesalers that are out there locking up deals and then flipping them to another buyer and earning a fee on it without the seller's knowledge. That's what this form is designed to utilize, so that we can make the proper disclosure so the seller knows exactly what's going on and whether somebody is profiting off of their property, which they should be made aware. Okay, so that is our assignment of agreement. Okay, let's keep going. All right, I hope you don't have to use this one, but it is what it is. Cancellation of contract, release of deposit, cancellation of escrow. If a deal is going to die, here is the document that you're going to use. So basically, you're going to note, is it in accordance with what? The purchase agreement or maybe some other document? Basically, where is the cancellation right coming from? And then you've got two sections. One is cancellation of contract, and one is release of deposit and cancellation of escrow. Now, the cancellation of contract is the first part. And basically what we would do here is we would make a note over why the transaction is being canceled. Okay, is it because it's permitted by a paragraph in the contract? Maybe the investigation or the loan contingency or the appraisal contingency, all those would be reasons for a buyer to be able to have a right to cancel. Or maybe it's because a notice to buyer to perform was delivered and has not been removed, or they didn't take the action, whatever the action was, that's outside of the contingency, right? Those are contractual actions like putting your deposit into escrow. It's not a contingency for the buyer, but it is a contractual obligation. And if the buyer didn't put their deposit in, you would send this form and check the appropriate box. Okay. There's also notice to seller to perform, notice for seller to take the applicable contractual action as well, per mutual agreement or other. Okay. So you need to basically state what the right is to cancel escrow. The second part of this is to release the deposit. Okay, so we're going to cancel and cancellation of escrow. We're going to cancel an escrow. There's a place to put the escrow number and the company name. And then what happens to the deposit? Seller releases it, buyer releases it. They instruct escrow to hold the money until there is a judicial decision or an arbitration award or other. Okay, so I put in here deposit to be refunded in its entirety. Now, one thing, just FYI, guys and gals, read your escrow instructions. Sometimes escrow companies will slip in a cancellation fee that I've seen anywhere from $50 to $500. And I don't think your clients have to agree to that. In fact, whenever I see that in my escrow instructions, I actually tell my clients to just cross it out and put an initial to it and say, we don't agree to a cancellation fee because you guys don't charge cancellation fees. Title doesn't, right? Why should the escrow company? So anyways, oftentimes that's why we write deposit to be refunded in its entirety. Now, I do want to make a note here. The cancellation and the release of deposit and cancellation of escrow are two different things. So you can have the cancellation of contract signed and still have a dispute over the deposit waiting for resolution, whether that is mediation, arbitration, small claims, whatever. So for sellers, that would mean the transaction's still canceled and they could go on and proceed and sell to another party, but the deposit would still be in question. Okay, so this can be essentially executed in counterparts, or you can check the C box and leave the money in escrow until there's a decision about the disposition of those funds. Okay, so again, hopefully you won't ever have to use those, but the reality is you will cancel escrows. The more business you do, some of them just aren't going to work out, and that is part of the business. So factor in cancellation rate when you do your numbers. Okay, next, going on that same vein, the demand to close escrow. Okay, so there is no notice to perform for the close of escrow date, but there is a demand to close, and that's what this is, right? So it basically says we, the seller in this case, are demanding that you close escrow within, right, 3 days after the receipt of this demand, but no earlier than the agreed upon close of escrow, or by blank date, which is at least 3 days after receipt, but no earlier than the agreed upon close. So you can't force somebody to close early, okay? But you can deliver this before the close of escrow 3 days, because it gives 3 days to close, right? So there's a seller demand and there's a buyer demand, okay? Now, I just want to share something that I see happening a reasonable amount of time right now. Neither party is obligated to give an extension for the close of escrow. And if you're late and the seller delivers this to your buyer and you've removed all your contingencies and they're threatening to cancel, they have the right to do so. There's not much, I mean, you got to negotiate your way out of it. There's not too much you can do to really, force the issue. Okay, if that's the right verbiage. So if the seller wants to cancel, then they will have that right to cancel. And so with that said, guys, bigger picture, don't let your timeframes get close or come and go without addressing them in some way, extending the time. And you don't want to be bargaining to try to get more time for your close of escrow or your contingencies after the time has expired. So what I do is when I open an escrow, I put in my calendar, I put all my contingency dates, and then I'll put a little reminder for 2 days in advance, at least, right? But if I know the loan's not going fast enough, or the appraisal hasn't even been ordered and we're on day 15, or 14, I know we're not going to be on time. So I'm going to call the other agent right then and start negotiating for extensions beforehand, right? People are far more likely to work things out in advance and not afterwards. So please don't let your timeframes expire. Always address them in whatever fashion that might be, whether it's your seller giving the notice to perform, whether they intend to cancel or not, or negotiating for extensions, etc. Okay. So there's our demand to close. Let's keep going. All right. Speaking of timeframes, here's the extension of time. Okay. So here's where we're going to extend any sort of time that we may have, whether it's the close of escrow or contingencies or other. Okay. There may be other as well. Okay. Okay. Thank you for that. Communication is so key. So often I hear of agents that the other side just disappears for, a week at a time, which, by the way, is a violation of the code of ethics. We have to respond to our fellow associates in a timely fashion. So again, this is where we're going to extend escrow, extend contingency timeframes, extend other maybe contractual obligations, timeframes to deliver disclosures, get the deposit in. There's a ton of different timeframes that are all inside of our purchase agreement that you can alter. And then you'll notice here there's an additional paragraph, number 4. And this is where you may need to, negotiate, especially if it's for your buyer. I've seen twice just in the past couple of days where we're beyond our close of escrow and the seller's delivered a demand to close. The buyer is not going to be in a position. We were both of our buyers at our company. They weren't in a position to close. And so I told the agents what I've seen work is, basically releasing all or a portion of your deposit or a per diem, some sort of financial incentive for the seller to keep the deal going and not just arbitrarily cancel because it lost faith. Okay. So, money tends to speak. So think about what it is that you can use as a carrot to get one of these extensions signed. Okay. Very simple, right? Put a time frame in and sign and date and send. By the way, just by sending an extension of time addendum doesn't mean it's agreed to. Doesn't mean the seller even has to wait for a response if the buyer's the one that sends it. Okay. The clock is still ticking no matter what. So don't just think because you sent it that they're obligated to give you any sort of response. Okay. All right. Let's look at this one, the RFR, receipt for reports. I rarely see these in files, and I think they're so valuable because it just is a declaration and an acknowledgement that whatever party it is, the buyer in this case, has received whatever documents, whether it's a document, an inspection, a disclosure. I was speaking with an agent today. There were insurance claims on the property, and they said, "What's the best way to, not only tell the client about the insurance claims, but also to, deliver some of the invoices for the work that was done, et cetera, et cetera." And I said, "Well, first of all, to disclose it, you would do that on your seller property questionnaire. And if you've got documents you're in addition going to deliver, this is it right here. This is what you would use. And look, there's all kinds of places for other documents, who they were prepared by, when they were dated. So this is a great form and a great tool just to deliver docs, disclosures, inspections, et cetera, and have the buyer acknowledge that they did indeed get a copy of them, and they just sign that. It's simple, right? Couldn't be easier, but a great one in here. Even for something as simple as the inspection or the termite, you can use this document, okay? Very simple. Let's keep going. The next thing I got here, referral fee agreement. I get this question from time to time. What do I use to generate a referral to another broker? Well, there you go. Here it is. Referring broker is the person that's sending the referral out. Recipient broker is the one that's receiving it. And you would fill in, your name, all the company information, the principal, i.e. the buyer or seller's information, the amount of the referral, the length that it is in existence for, and then when do you get the referral fee? Is it when they buy or sell or lease, and within what time frame? And then for the referring broker, if that's us, we would put our information here. And if you need our tax ID, just text me or DocuSign the form to me and I will fill it in for you. And then sometimes when we send a referral, the other office needs a W-9. Again, just let me know. I've got some of these completed already for you. Okay. So this is the form, works nationwide, no problem. Some agents are going to have their own forms, which generally are sufficient. And either myself or one of our managers, MCAs, will sign these for us. Okay. Easy peasy. All right. I did include this, just why not? Request for repair. Okay. As easy as it sounds, this is the document you're going to use to make a request. There's multiple things that you can request on here. You can request items to be completed for repairs, right? Fix the plumbing, fix the roof, whatever. There's also a section for termite, section 1, section 2. Pretty common if you're going to ask for termite that you're only going to do the section 1 work. There's a checkbox here for a credit. And then there's a checkbox here to reduce the price. And you could use all of these if you wanted. Maybe you're going to ask for a couple things to be fixed and for the termite work to be done, plus $1,000, plus a reduction in the price. You could do all of them on the same document, okay? And then there is an area here where you can check in here if there's additional reports or inspections that you're going to include with your request, okay?
Hey Nick, it's Katie. Yeah. I happen to be filling out one of these forms at the very moment.
Okay.
And so, I mean, I've used this, of course, many, many times. We have an agreement where the seller and the buyer agree that the buyer will pay up to $20,000 over the appraised price.
Mm-hmm.
So we got our appraisal in. It's just shy of the sales price. Can I use this form to do that?
To change the price?
To change the price, even though it's not specifically related to the repairs?
I think so.
Okay.
Yeah.
I mean, that's what I was going to do. And I thought, oh, well, how timely that you're talking about it.
Yeah, right. I mean, is it the absolute correct form? Probably not. But yeah. I don't think that it would be, I don't think the agreement would be invalid by it not being on an amendment.
Okay. Yeah, I was just thinking it's a very small shortfall. So I thought, well, I'll just use this. Okay, thank you.
Yep, you bet. Absolutely. All right. The second part of our form here is the seller's response. And the seller can respond in multiple fashions. One, they can agree. Two, they can not agree. Or three, they can make a response on our, what we jokingly call our pirate form, the RRRR. Okay, so last joke I tell today, I promise you. So basically, if the seller does agree to all of the buyer's requests, they can also demand that not only does the buyer remove their inspection contingency, but possibly other contingencies as long as they're due. Okay, you can't, preemptively ask for the loan contingency to be removed as well if you're only on day, 10. So there is a box there to declare that though. And then if the seller does agree, then the buyer can then confirm that they are indeed removing their inspection contingency. And I've had this question come up. Do they need to sign a CR form? And what I read here is, if seller agrees to all buyer's requests, buyer hereby removes the inspection contingency. So it says hereby removes, not, is required to remove on a CR. So I think by signing this as the buyer, you are in fact removing your inspection contingency. And then anything else that might be on the CR would need to be signed by the buyer. Okay. All right, so that is our RR. Now, what happens if the seller doesn't agree but does respond? Well, let's jump a few forms here and take a look at that. We have the RRRR, seller response, and buyer reply to request for repair, and that would have been number 1, right? That was the first repair request we got. So the seller can now decide how they're going to respond. Are they going to do everything the buyer asked for? Accept something, right? Maybe they just take one thing out, or will they offer a credit, or will they reduce the price, or will they do something else? And this is the response section. Now the seller can then say, we'll only agree to this though if you remove your inspection contingency, which is a default, by the way, that cannot be changed, or remove other contingencies as identified on a CR. Okay. Now, if the buyer agrees to the seller's response, all they have to do is sign. Okay, but they have some options too. They can say, we agree, but instead of that $1,000 credit, we want $1,500. Okay, so if you type something in here, you're basically modifying what the buyer's agreeing to from the seller's response. Now, if you modify something, the seller will then have to come back and re-sign by either agreeing or not agreeing. And if the seller does not agree to the buyer's modification, then the buyer can do another repair request. Okay. The other option here is that if the response is not favorable to the buyer, 1C says here the buyer can request another RR, and that would become number 2, right? And then they would fill out a whole new repair request form with everything that they're asking for at that point. I've seen as many as like 3 or 4 of these, which I kind of think is a little crazy. For me, going back to Katie's comment, communication is key. Pick up the phone. Negotiation should be, in my opinion, a conversation, bouncing stuff back and forth off the agent and getting a sense of like what is likely, what's probable. And then you can go back to your client, advise them and help them draft up their repair request. It shouldn't go back more than once or twice. Same thing with counters. That's just me. Okay. That's just me. All right. That's the RRRR. Let's see what else we got here. I do have in here the residential lease after sale. This document is for possession. And I am going to go and do a little deeper of a dive on this form in our next contracts class, because I want to talk about contingency for sale, contingency for purchase, and then possession, because these are so crucial that you really are thoughtful about how to draft these to protect your clients, buyer or seller, to be thinking about the timeframes that are involved, like when your clients need to move. And many people are needing to sell a house in order to buy another home because prices are shooting through the roof, as we all know, okay? And so with that said, we have these protections, we have these agreements. We'll do a little bit deeper of a dive, but this is basically a full-blown lease if a seller is going to stay in possession of the property they sold for 30 days or more, okay? Intended for possession of 30 or more days. So what all's in here? You know, it's a 5-pager and it's just like a normal residential lease agreement. There's not much different here. I will say, again, I'll do a little bit more of a deeper dive, but make sure that you take the time to go through and read and fill this guy out. I think that to protect your buyers and sellers, you should have some sort of a fee. There should be a deposit. There should be at least a deposit, if not an actual agreement to buy the time. But for sure, you want something staying in escrow to give the seller incentive to vacate when they're supposed to vacate. Okay, so keep that in mind. Now, this is for 30 days or more. We also have the SIP form down here. This is for 29 days or less. Okay, seller licensed to remain in possession. Now, this is a license, not a lease agreement. So it's basically, it's almost like a short-term versus a long-term rental, Airbnb versus a long-term rental, right? This would be more like an Airbnb type of a deal where you're given the license to stay in the property, but you do not have a lease agreement. Now, I get this question from time to time. Well, so if the seller stays past their license time, can't we just force them to move? Well, you can't force anyone to move. You still have to evict them for being unlawfully in possession of the property, right? The unlawful detainer action. So one thing about that I wanted to tell you. And then another thing that I wanted to tell you. I had this question come up numerous times. When a seller sells a home and is renting back the property for any amount of time, 1 day or 6 months, does the buyer get a set of keys? Does the buyer get keys to the house? Okay. The answer is maybe. The answer is maybe. If it's the residential lease after sale that we just saw, the answer is yes. That's their home. They own it. And they're supposed to still be given possession of the property in terms of at least the keys and anything else in a similar function, garage remotes, et cetera. Okay. Doesn't mean they can go on the property, but unless they give proper notice, right? 24-hour notice of entry for an appropriate reason. Now, what about if there's a license? Well, guess what? There's a paragraph for that. Keys. Seller shall provide keys to the property as required in the agreement at close of escrow. So in both cases, the default is that, yes, the buyer is supposed to get a copy of the keys. This has an option to say, no, the buyer is only getting keys after the seller vacates. Okay. So there you go. All right. Keep it on moving here. Let's see here. We have our VP, verification of property condition, or commonly known as the final walkthrough. As we know, the buyer has a right to conduct a final walkthrough 5 days prior to close. It is not a contingency of the agreement. It's just a right to walk through, make sure repairs are done and the place is in the same condition as originally agreed. Now, this question comes up from time to time. Can the buyer not close if repairs aren't done or if something is damaged in the property? Well, the answer is basically no. It doesn't give them the right to not close escrow, but it doesn't mean they're waiving their rights to recourse. They can still, pursue a seller in small claims if there's damage or a repair wasn't agreed upon, but it doesn't mean they are given the right to not close. You can try to use it as leverage and say, we're not going to close unless you fix these things, but the buyer is not automatically given the right to extend their escrow time frame. Okay, so keep that in mind. And it's simple. If the place looks like it did when you originally toured and the buyer is happy with the current condition, all they do is sign, right? They don't need to type anything in here. Sometimes I see people write in here, buyer accepts property as is condition, or place looks great, or whatever. You don't need to put anything unless there's an exception. An exception being, damage to the floor, blah, 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 right? That's it. Okay, that's our VP. Let's just chugging right along. I have a counter offer in here. I'm not sure why that would be in our contracts class, but I will go to the next one. Withdrawal of offer is a good one. Many people didn't know this exists as well. This form is used to withdraw or revoke an offer or a counter offer. Okay, so a buyer made an offer and it has not been accepted. This form is for the buyer to withdraw the offer and say, we are no longer, that offer is no longer valid, okay? Or it says the buyer seller has issued a counter offer that can be withdrawn as well. And then number two is withdrawal and revocation. So either party, buyer or seller, is withdrawing and revoking whatever the document is, okay? And it can be replaced potentially by something like a multiple counter offer. Okay, so if you're a seller, listing agent, you receive an offer, you send a counter offer, not a multiple counter, just a normal counter, and then all of a sudden you get two more offers and you haven't had a response yet. You can send this document to revoke the counter offer that was sent and then reissue a multiple counter offer. Time is of the essence. Make sure that happens ASAP. All right. Now we are cruising through this. Let's go. Next one.
Nick,
Yes.
can you elaborate multiple counter offer, please?
So a seller multiple counter offer basically means the seller is making a counter offer to multiple parties. And if a buyer accepts the terms, it's still not binding because the seller then has the right to go back and choose any of the people that they responded to or somebody else. Okay. So you could have 5 multiple counter offers out to 5 different buyers. And what that form does is it protects the seller from being obligated to sell to all 5 of them at the same time. Okay. Does that make sense?
Yeah, thank you.
Awesome. Here's another good one. Property visit and open house advisory. Now, here's the thing. This came out in the middle of COVID, and guess what? We weren't doing a lot of visiting, and we sure as heck weren't doing any open houses, as you all know. So what is this? It's a form that just talks about the risks of visiting and viewing properties. So this is something that you would use one time with your buyers as you're out showing, and it talks about things like recording devices. You may be being recorded. There may be a smart speaker in the house. There may be a camera security system that is recording you video and audio, right? There is a paragraph here for visitor safety. Okay, so making sure that you are protecting yourself physically from any harm. There is a paragraph for animals, pets. That may be a source not only of unpredictable behavior as it states here, but also of maybe allergies, right? I'm allergic to dogs. I'm even allergic to my own dog, right? It takes me a few days to get acclimated. So, but there you go. Accompanying minors. Visitor has got to be responsible for their kids or the kids that are in their care. Risk of injury. Okay, so this is basically saying, hey, going into other people's homes poses potential risk, and we just need to tell you about it. So this would be a good one to sign for your buyers. If you can at open houses, it's probably a good one to have every visitor that goes into an open house. Okay. Can that be a bit of a pain? Absolutely. But think about the upside, right? You're protected in the sense that we warned you against falling and injuring yourself or, getting bit by the lizard or whatever it is. Okay. So Will it be a little tougher to get this signed? Yeah, but guess what, right? We're in a very litigious industry. Number two, after medical, right? Realtors and real estate transactions have more lawsuits than any other industry minus healthcare and medicine, okay? So it might be wise to get this signed. By the way, you heard it here first. Tomorrow, it appears PEDs are going away, hopefully forever. So that's pretty awesome, unless some local regulations come in that's more strict, but it does not appear to be the case as of right now. Let's keep rolling. Okay, backup offer addendum. Here's another good one, right? So I'll hear agents say, oh, I submitted an offer, the seller didn't take it, but they're gonna keep my buyer's offer as a backup. In my mind, I'm thinking, did you get the addendum signed? And 99.9% of the time, I know the answer is no, okay? Now, here's the thing. Most sellers are probably not gonna wanna sign one of these, right? Because who knows, in a market that's moving so fast, they might be able to get more money. Okay, so in the current market, it would be beneficial for your buyer to sign it. A savvy listing agent and seller are probably not going to allow this to sign this document, right? Because again, it binds the buyer and the seller to work together if the current transaction falls apart. Okay, but valid, useful form if you can get it signed on your buyers. Vibor, yeah, tomorrow PEDs are going away, June 15th. The world is opening back up, right? So basically, just FYI, and I'll cover this in some of our team meetings, but as of tomorrow, all restrictions related to coronavirus are gone. No more PEDs, no more coronavirus addendums, no more posted rules of entry, no more best practices and COVID prevention plans, et cetera. The only thing that is staying is essentially masks. And I say essentially because if everybody at a showing is vaccinated, no one needs to wear masks. Now, I don't think many of our agents are going to want to be the people that are going to go around asking all their showings, are you vaccinated? Can be a little bit of an uncomfortable question. Can you ask that question? Yes. Okay. Car Legal did a webinar on this. And they said you can ask everybody whether they are vaccinated or not, yes or no. And that's the extent of it. That's it. Obviously, you're not going to ask why or why not, or any other medical information about the client. Okay. So, if you want to ask everybody at an open house if they're vaccinated as they go into a property, you're welcome to do so. Or the easier solution is, for the time being, just continue requiring everybody to wear masks inside the property. Okay, so there you go. The only other issues would be if you're holding an open house with more than 5,000 people. Okay, so yes, that is actually a thing. And no, you will not be having one like that. So there you go. Let's keep going. Okay, I almost hate to show these two forms, but I'm gonna anyways. Buyer early occupancy addendum. I just want you to know this form exists. This would be if the buyer is gonna move in prior to close. I absolutely never, ever, ever recommend this happening. There's just so many things that could go wrong. It doesn't make a lot of sense, okay? So essentially, if your buyer asks, just tell them no. Right? But basically, it's like a reverse lease. The buyer's moving in and is going to take possession of the property. So anyways, for your sellers, just tell your sellers don't ever agree with that. Okay, but it does exist. I have to tell you it's there. There's another one kind of similar, and that is the buyer pre-occupancy storage addendum. I'm a little bit looser on this one. If your client really has to put something in the garage or whatever, they can do that. There is a document designed to protect all parties. Again, at the bottom, brokers do not recommend pre-occupancy storage. The other one said brokers do not recommend early occupancies for a human being as well. So anyways, in the rare crisis, ultra extenuating circumstance, you can reach out to me and we'll troubleshoot and talk about it. But I'll show you that those exist. Just don't ever use them. All right. Let's see. We talked about counters. Let's look at the notice to perform and contingency removal. Basically, it's super simple. If a time frame is coming up, a seller can deliver a notice to buyer to perform, right? And the notice to perform is either going to be regarding a contingency or a contractual action. Most of the major ones are listed here, right? We know we've got loan, appraisal, disclosures, condo, or planned unit development, buyer's investigation, including insurability, prelim, the sale of buyer's property, etc., or contractual actions, which would be things like deposits, the FVA form, the FHA VA mandatory clause, proof of loan approval or closing costs or cash to close, etc. And the seller will deliver this to the buyer no sooner than 2 days or what's in the contract. And for some of you who have seen my RPA video, I changed my notice to perform time frame to 3 days. That way my buyers, at least on my offers, the buyer has 3 additional days to either perform or remove their contingency. So I try to buy a little time. Also, FYI, folks, all the time frames in the contract cannot expire on a weekend or a holiday. Okay, so if you have let's say you get a notice to perform on Thursday, 2 days would be Friday, Saturday, right? It can't expire Saturday, it can't expire Sunday, so it gets pushed to Monday. Okay, so keep that in mind. I get this question a lot as well. When does the clock start ticking? So if you receive the notice to perform, whatever day that is, that's day 0. That's the receipt. So if you receive a notice to perform on Thursday, that's day 0. Friday is day 1. Saturday would be day 2. Gets pushed to Monday because it can't expire on a Saturday or Sunday. Okay. All right. Let's keep going. Right after the notice to perform was our contingency removal, which was referenced in our RR and the RRRR. That's a lot of R's. Well, here's the CR. Okay. So again, removal of contingencies. And this is where the buyer removes either whatever you check or all contingencies except or all contingencies. Okay. So basically, it's just the form that we use to remove as appropriate or as required. Now, there are seller contingencies for like finding replacement property, things of that nature. This form can also be utilized for exactly that. There's also a seller notice to perform, which I've actually seen being utilized more and more recently for, not delivering documents in a timely fashion to close escrow, not delivering disclosures. There's some wacky stuff that I'm seeing out there right now. So anyways, interesting times for sure. All right, couple more here. So we have the RCSD, Representative Capacity Signature Disclosure. There's one of these for buyers and there's one of these for sellers. Basically, all this is declaring who is the authorized signer on behalf of an entity. An entity might be a trust, a corporation, an LLC, a partnership. It might be a power of attorney. There might be an estate being sold through probate. Okay, so the way you use this is you basically state that the entity, right, might be the Bob Buyer Trust, right? Is selling a property. Oh, I don't know if I'm going to spell that out or what. There we go. Okay, Bob Buyer Trust. And then down here, you would make a note that Bob Trustee, right? The trustee of the Bob Buyer Trust is the one that is signing on behalf of the parties. Okay. So that's where we use the document to declare who is signing on behalf of an entity. There's a couple of boxes here for when is this form being used. Is it at the time of sale, meaning you're entering into a purchase agreement, or is it at the time of a buyer representation agreement, a buyer contract, right? The RCSD seller will be similar, but it'll have a listing agreement noted on here as well. Okay. All right, so that's the RCSD buyer. As I mentioned, there's one for seller here as well, okay? Let's see here. Tenant in possession. We have seller in possession. We have the buyer early occupancy. Well, what if a tenant is staying? Well, remember, Nick said there's probably a form for that, and here it is. Tenant in possession, it just basically is noting what the tenant's rights are pursuant to the lease. the rental documents that will be provided. And then there's a paragraph here that talks about if there's a proposed change to the lease terms, that the landlord will notify the new buyer because altering that lease may affect the desirability of the property. Okay, so again, simple one pager. And if you're using the residential income purchase agreement, there's a few other things that talk about, delivering deposits to the new buyer and so on and so forth. Okay, so that's the TIIP. And then let's see. We said there's a notice to buyer to perform. As I mentioned, there is a notice to seller to perform. Okay. By the way, the notices to perform, they're also backed up in the sample letter library for demands for seller to perform and demands for buyer to perform. And what they do is they actually spell out a little bit more in detail about what a buyer or seller could do if they do not perform. Typically meaning, collecting financial damages, lawsuits, specific performance, list pendants, that kind of stuff. Okay. So notice seller to perform is very similar to the buyer. It's just a list of all the different things that they're responsible to do in the contract. And here's where we say, you haven't done it, please do so. If you don't within 2 days, the buyer has the right to cancel the agreement. Okay. In this market, you're probably not using this very often because frankly, your buyers don't want to cancel. They want to buy the property. All right, we looked at the amendment of existing terms. Here is our addendum, okay, where we're incorporating new terms into the purchase agreement. As you can see, it's pretty much just a bunch of blank lines. So that is our addendum, okay? This addendum could also be used to add information to the TDS or the seller property questionnaire, okay? Is that it? Let's see. One last one right here. Additional broker acknowledgement. If you're going to co-list a property with an outside broker, or you're going to represent two different brokers and agents are representing the buyer, then you need to fill this form out. Okay. So co-listing brokers might be Keller Williams Pacific Estates and Keller Williams Pacific Estates La Mirada. Two different agents are working together. If you're going to co-list or co-represent a buyer on a transaction, we need to basically discuss what the responsibilities and the compensation are for the different brokers. Okay. So there is a couple of lines here that talks about agreeing to share responsibility and compensation as follows. So this is where at minimum you would put in there who is getting what % of the commission. And then ideally you would actually draft up, and in this case, maybe attach an addendum here and talk about who's doing what. If it's a buyer, like who's conducting the showings, who's writing the offers, who's conducting the investigations and negotiating repairs, right? We need to disclose all that properly. You can't just, you're not supposed to just sign this document and say, oh yeah, two brokers are working for you, FYI. There needs to be a little bit more involvement here by disclosing what exactly that looks like, okay? All right, and then if you're gonna have multiple agents at the different brokers, you would, in addition to this, use the additional agent acknowledgement. All right, that is that. Most of these are just simple one-pagers, not a lot. So my question to you is, are there any questions that I can answer for you before we wrap up for the day?
Nick, you showed us earlier a license for the buyer or for the seller to remain in the property 30 days or fewer.
Yep.
Let's say they needed more time to pack and move, whatever it might be. Is that, I was familiar with another agreement that's like a lease back. So a buyer lease back. Is that different than the license, or are they essentially the same thing? Or
so the license is for 29 days or less.
mm-hmm.
The residential lease after sale is for 30 days or more.
So those are the only two options then.
That's basically it.
For that scenario.
Yeah, and what it comes down to is just basically rental law in California. If you have a lease of 30 days or more, you need a full-blown lease agreement. A license is not sufficient.
Okay, appreciate it. Thank you.
Yep, you got it. And we did cover both of those in this video, but not in depth. Well, we will do another in depth where we'll break down more line by line these documents. Anybody else? Okay, not hearing much. I'm going to wrap it up. I will stop our recording. As always, we post these in our YouTube channels, right? So we can